Amy Mitchell. I'm the Director of the Office of Energy System Planning and Performance at the New York State Department of Public Service. I've been designated to serve as the alternate representing the chair of the New York State Board on Electric Generation Siting and the Environment, or as is also known, the Siting Board. I call this meeting of the Siting Board to order. Before moving to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board. When I call your name, please confirm that you are present. Mark Sanza, alternate representing the Commissioner of the Department of Environmental Conservation.
Present.
Kevin Malone, alternate representing the Commissioner of the Department of Public Health.
Present.
Vincent Ravishir, alternate representing the Commissioner of the New York State Department of Economic Development.
Present.
And John Williams, alternate representing the Chair of the New York State Energy Research and Development Authority.
Present.
Thank you all. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda. I would, however, like to note that due to technical difficulties in New York, we are now using Video Conference Room B, and I believe appropriate signage has been put up to direct any members of the public to that location as opposed to the boardroom. Thank you.
Thank you, Secretary Phillips. We will begin with Case 15-F-0122, application of Barron Winds, LLC for a Certificate of Environmental Compatibility and Public Need pursuant to Article 10 to construct a wind energy facility, Amendment Petition 2, and Transfer Petition. Presented by Dakin Leacakes, Chief Administrative Law Judge, Department of Public Service. Jason Zaire, Chief of Environmental Certification and Compliance, Department of Public Service, and John Sipos, Deputy General Counsel, Solicitor, and Director of the Office of Investigation and Enforcement, Department of Public Service, are available for questions. ALJ Leacakes, please begin.
Thank you. Good afternoon, Chair-Designee Mitchell and Siting Board members. I am here to present to you a draft order on a Second Amendment petition in which Barron has requested further changes to its Article 10 certificate that the Board issued to Barron in 2019. In that September 2019 certificate, the Siting Board approved a project that would generate 242 megawatts of clean, renewable electricity by up to 69 500-foot tall wind turbines placed among 4 towns in Steuben County: Cohocton, Dansville, Wayland, and Fremont. The Siting Board considered and granted a First Amendment to the 2019 certificate in May of 2020. In that First Amendment order, the Siting Board allowed Barron to divide the project into 2 phases. Phase 1 would proceed in 3 of the 4 towns, Cohocton, Dansville, and Wayland. Because there was no conflict with local laws in those towns, the Siting Board granted to Barron an increase to its per-turbine generating capacity from 3.5 megawatts to 5 megawatts, which, although it increased the turbine size to 650 feet, allowed the developer to place only 26 turbines in Phase 1 and generate the planned 166 megawatts for that phase. In his May 2020 presentation on Barron's requested Phase 1 amendment, General Counsel to the Siting Board, Bob Rosenthal, noted that if Barron used the September 2019 authorized 500-foot turbines for Phase 2, the project would host a total of 54 turbines to reach its authorized 242 megawatt generating capacity. Although if the developer was able to use the 650-foot turbines, the total number necessary to reach its maximum planned generating capacity could be reduced to 48. In July 2022, while Phase 1 was under construction, Barron submitted an amendment petition for Phase 2 requesting, among other things, an increase to the maximum turbine height that would also allow for improved per-turbine generating capacity. To accomplish this, Barron also requested that the Siting Board waive the town of Fremont's wind turbine siting law's maximum height restriction of 500 feet. Of note, Phase 1 began operating in February 2023. After receiving the Phase 2 amendment petition, Siting Board Secretary Michelle Phillips sent a letter to Barron's counsel informing them that the request was considered a revision under the Siting Board's regulations, requiring the completion of an evidentiary hearing and findings by administrative law judges. The Secretary's determination was based in part on Barron's representations that a number of Phase 2 turbines would be substantially relocated from their original planned positions, and because the height request was prohibited by Fremont's local law, which would require a siting board waiver. For the Department of Public Service, I assigned the case to Judge Maureen Leary and my counterpart, Michelle Stefanucci, Chief Judge at the Department of Environmental Conservation, assigned the matter to Judge Jennifer Eucharitis. I wish to express my appreciation to Chief Judge Stefanucci and Judges Leary and Eucharitis for their efforts, allowing me to present this draft order to you today. Ultimately, the judges recommend that the Siting Board grant the amendment with only slight modifications to the 2019 certificate's conditions and restrictions. The most notable disputed issues concern noise modeling, shadow flicker, stream crossings for collection lines, and decommissioning funding requirements. It is not a coincidence that these issues have been informed by Barron's compliance filings and other experience related to its Phase 1 construction and operation. Starting with noise, the draft order makes no changes to the 2019 certificate conditions operational noise limits, as none were sought. Rather, DPS contested two notable issues related to noise modeling. The first concerned an issue that was discovered during the compliance process for Phase 1, where Barron had adjusted its modeling protocol and incorporated noise reduction operations directionally, meaning that they were only used when a receptor was downwind of a turbine, despite the 2019 certificate conditions having been based on a protocol that accounted for noise reduction operations in all directions when wind conditions exceeded tolerances. The Public Service Commission discussed this issue in a December 2022 compliance order, and the draft order before you requires Barron for Phase 2 to apply NROs consistent with its initial application sound modeling protocol and the board's 2019 certificate. The second noise issue concerns the reliability of the modeling, given that Barron has been unable to provide the manufacturer's sound power levels for the specific turbines being considered for Phase 2 due to their still being newly developed. Instead, Barron had provided sound power information for a similar model turbine, but one that has a slightly lower power generating factor. The judges determined that the record did not support a conclusion that the information provided was substantially similar to allow for the sound power numbers to be considered sufficiently representative of the newer turbines. To resolve this issue, the draft order requires Barron to either submit as a compliance filing the manufacturer's sound power information if it becomes available prior to construction, or, in the event the information remains unavailable, Barron will be required to hire an independent consultant approved by DPS staff to redo the pre-construction noise modeling and to submit a revised Phase 2 pre-construction noise impact assessment and noise reduction operations plan. Turning to shadow flicker, once again, the draft order makes no changes to the Siting Board's 2019 certificate limit of 20 hours annually for non-participating landowners. The draft order requires Barron to submit updated modeling as a compliance item to clarify the number of receptors expected to receive more than 20 hours annually and those expected to experience more than 30 hours annually from Phase 2. We anticipate that the compliance item will clarify some inconsistencies in the record. In addition, the draft order requires Barron to clarify that shadow flicker complaints should be resolved within 30 days, and if complaints cannot be resolved by then, absent extraordinary circumstances, curtailment should be employed to achieve compliance and complaint resolution. In addition, the 2019 certificate requires Barron to consult with the New York Department of Transportation on a study of potential shadow flicker impacts to State Route 21, based on concerns raised back then by the town of Fremont. While Barron did testify that it contacted the Department of Transportation, it notes that it received no response. The draft order requires Barron to continue its efforts to consult with DOT and notes that DPS staff should assist if necessary. During Phase 1 construction, Barron experienced 9 inadvertent returns and drilling fluid releases from its use of horizontal directional drilling and the resulting impacts to protected wetlands and streams, 2 of which occurred at Neals Creek, a protected stream under Title V's permitting requirements in Environmental Conservation Law, Article 15. DEC staff noted that crossing Neals Creek will also be required during Phase 2 construction. While the draft order reiterates that horizontal directional drilling should continue to be the only crossing method used for the Phase 2 project for most crossings, it accepts Neels Creek without further study and requires that the crossing method ultimately used for Neels Creek should be subject to DEC and DPS consultation and oversight. To ensure this takes place, Barron is required to submit a revised inadvertent return plan addressing crossing alternatives for Neels Creek in greater detail and include not only the information agreed to by the parties in a post-hearing stipulation, but also identifying the nature and extent of environmental impacts associated with each alternative it discusses. Additionally, the draft order requires that Barron's revised inadvertent return plan include, among other things, an independent environmental monitor with shared responsibilities with the site supervisor and foreman to oversee horizontal directional drilling activities and immediately report to DEC staff and DPS staff any spills, releases, or inadvertent returns and any remedial activities undertaken. As for decommissioning, Barron requests that the 2019 certificate's $9.764 million minimum amount for overall decommissioning and site restoration costs for both Phase and Phase 2 be reduced by $1.25 million based on the expected reduction in the number of turbines necessary to achieve its allowed 242 megawatt generating capacity. Both Fremont and DPS staff opposed Barron's request. The draft order notes that as an initial consideration, the reduction is inconsistent with the town of Fremont's wind law, and Barron did not seek a waiver of that particular provision. In addition, however, the draft order includes the judge's conclusion that the record was insufficient to demonstrate that any reduction was warranted and that Barron should provide, in compliance, a Phase 2 decommissioning plan with updated costs, including an inflation factor, something that was absent from its plan that was included with the amendment petition. While that ends my review of the most significant substantive environmental impact issues, there are two more issues that I would like to direct your attention to. The first concerns a request to transfer a portion of the ownership of the 2019 certificate from Barron to a newly created company, Barron 2. The transfer application would keep Barron responsible for the now operational Phase 1 project and make Barron 2 responsible only for the construction and operation of Phase 2. While the transfer petition asserts that Barron 2 is qualified to carry out the provisions of the 2019 certificate and any orders issued with respect to Phase 2, the petition acknowledges that Barron 2 has no investors and will not until the Siting Board takes action today on the amendment petition. However, not to completely frustrate the proposed transfer, the order finds that the local communities will be protected, making the transfer in the public interest if Barron and Barron 2 file as a compliance item a written agreement binding each entity to jointly and severally comply with the certificate's terms, conditions, and limitations, and with any order issued thereunder, without regard to the two project phases or separate corporate certificate holders. Of note, allowing the amendment, the Siting Board must take consideration of the town of Fremont's wind law that imposes a height restriction on wind turbines of 500 feet. The draft order finds that a waiver is necessary inasmuch as it is unreasonably burdensome in light of existing technology. The judges found Barron's evidence compelling that the use of 500-foot turbines, even if they are still available at the time of construction, would result in greater environmental impacts during construction, particularly as more sites would need to be used, a position that was fully supported by DPS staff. Before closing, I note that certain interveners participated challenging contract rights previously provided to Barron as participating landowners. The draft order explains that the Siting Board is not the proper authority for deciding contract disputes. It also explains that while Article 10 requires a developer provide its existing real property interests sufficient to construct a wind generating facility, the record demonstrates that sufficient property interests exist to meet this requirement regardless of the participation of the interveners contesting their consents or contracts. Finally, as a last-minute matter, I would like to bring to your attention comments received yesterday, Sunday, June 30th at 3:30 p.m., provided by intervener Chad Ziganthus. The comments are from residents of the local community that oppose the Barron project. Having reviewed the comments today, I note that they do not raise any new issues and can be considered addressed by the draft order, and that the issues raised therein are included in the comment summary in that draft order. I understand that those comments are being posted to DMM today at some point. Thank you for your time and attention, and we are available for any questions.
Thank you, ALJ Lee Cakes, for your presentation and for the thorough order before us today on these matters. And thanks to others as well for their contributions. I have no questions or comments. Let me turn to my fellow board members for any comments or questions. Mr. Sanza?
No questions or comments.
Mr. Malone?
No questions or comments.
Mr. Ravishir?
No questions or comments.
Mr. Williams?
No questions or comments.
Thank you. I now call for a vote. My own vote is in favor of the recommendations as described. Mr. Sanza, how do you vote?
In favor.
Mr. Malone?
I vote in favor.
Mr. Ravishir?
In favor.
Mr. Williams?
In favor.
The order is approved and the recommendations therein are adopted. Secretary Phillips, is there anything further to come before us today?
There is nothing further. However, I will note that the comments referenced by ALJ Lee Cakes have been posted.
Great, thank you. And we are adjourned.